Once again, thanks so much for attending. I really appreciate it. I'm always flattered that so many of you will show up to listen to an attorney speak. So a couple quick announcements. Next week, I've got the one and only Russell Gray, co-host of the Real Estate Guy, is going to be joining us to talk about raising capital and how to, basically build your brand and build your network to raise unlimited amounts of capital for your syndications. Probably one of the more popular talks he gives at the syndication seminar. And I wanted him to kind of do a condensed, I'm going to try and get him to do a condensed version of that presentation. And then more importantly, open it up to Q&A, which is the whole idea of this live, is that you actually get to ask people specific questions. So tune in. That'll be next Wednesday, same bat channel, same location. So let me just get going here. I'm just going to stop people still coming in. I don't want to be as distracted. So anyway, welcome back to the Real Estate Syndicator Live, episode 6, discussing how to legally incorporate capital raises in quotation marks to incorporate capital raises into your sponsor team. And as you guys know, if you guys have been following my content, I put capital raises in quotation marks because I don't really like the term at all. I'd rather you not use the term at all, whether it's in emails or spreadsheets or just in general. I think that's a dangerous term to use. That's why I always joke a little bit about the quotation marks. But hey, Mature from Canada. Today's topic is going to be a little bit more technical than I usually go, because I wanted to make sure that everybody was on the same page and understands why it is that there's issues bringing in quote unquote capital raisers into the syndication. And I'm probably going to say a couple of things that maybe you haven't thought about. And I want you guys to think about and just kind of realize that we are dealing with some complex matters. And as syndicators, you guys get away with not having to register as broker dealers for a particular reason. And I want you guys to be aware of it. So the first thing I'm going to talk about a little bit is just understanding that this all has to do with the issue of being a broker dealer, because anytime you are in the business of effectuating transactions that relate to the purchase of securities for other people, you need to register as a broker dealer, right? And so the syndication LLC itself, right, the initial issuer, which is the syndication LLC that we put together so that we can actually raise capital, that entity is not raising capital for others, right? It doesn't have to register as a broker dealer because it's raising money for its own account. It's the LLC, and we're raising money for the LLC. So there's no broker dealer issues there. It's also generally accepted that if you're just one individual that happens to be raising capital, even though you're not technically the issuer, you're not technically the syndication LLC, but if you're one person, it's generally accepted that you are also not raising money for somebody else, you're raising money for your own account. However, everybody else, the GPs, the managers, the employees, the managers of the GPs, the managers of the managers, any associated person that's not the issuer, that's not the syndication LLC, generally cannot raise capital without registering as a broker dealer. And so, of course, the question you're going to ask me next is, well, Mauricio, I've been syndicating for a while. I've done a ton of syndications. I don't register as a broker dealer. And the answer would be, you're absolutely correct. But the reason you don't have to register as a broker dealer is because there's an exemption that applies beautifully to you. And this is what people call it, the issuer exemption, but it's kind of a misnomer because it doesn't really affect the issuer, which is the syndication LLC. It actually affects all the associated persons. Like I said, the manager, the GPs, all that stuff. And so there's what I just call, and this is as technical as I'm going to try and get today, but it's called, we call a 3A4-1, which is the name of the statute, 3A4-1. That's the exemption that all of us rely on, all syndicators who you don't think of yourself as raising money for other people. But when you're doing a syndication, that's the exemption that we're typically relying on so that we don't have to have you go out there and register as a broker dealer. And so anybody who's an associated person, like I mentioned before, including employees, I've had some conversations over the last couple of weeks about people wanting to hire employees. And I was even at an event that I was speaking at, this was pre-COVID, so it was a couple of years ago, where somebody was discussing, oh, well, this person's an employee, so I'm kind of exempt, or, where they're obviously not capital raisers because they work for me or they're employees. there's no employee exemption. An employee is, again, an associated person of the syndication LLC of the issuer, and therefore the same rules apply to employees as to the GPs, as to the manager of the GPs, or the GPs of the GPs, however you want to cut it. And so the 3A4-1 exemption is a little bit complicated, but I've distilled it into really three main points. There's actually more than three. There's about 9, but most of them, or all of them, really don't apply to 99% of us. So we're not worried about you being a public company. We're not worried about you being a registered broker dealer or affiliated with a broker dealer. So it really comes down to these three things. And so I'll just go through them. So the first thing is that you cannot get paid what we call transaction-based compensation, meaning some type of compensation that's tied to either the amount of money that you bring in, or even a particular result, maybe tied to even a sales call or some kind of a specific transaction that happens. You cannot get paid transaction-based compensation or a commission, because that is the hallmark of a broker-dealer activity. And so that's what the SEC traditionally is really focused on, is whether somebody's getting paid transaction-based compensation. But the bottom line is, if you're getting paid transaction-based compensation, as I like to say, you're done. Like, you're dead in the water, end of conversation. We don't go any further. I mean, transaction-based compensation, you're done. And so obviously, if it's your own deal, if it's your own sponsorship, and you've got one or another co-sponsor, another person on your team, you're not getting compensated based on the transaction. You're doing the whole thing. But transaction-based compensation is the first big no-no in all this situation. The second prong to this test is that you, as a syndicator, must be doing what we call substantial duties. And again, if it's just you or you and a partner, then that's pretty straightforward, because you're doing all of it. You're not doing substantial. You're doing all the work that's involved in putting together the offering. And then once the offering is done, you're involved in all of the running the company at that point. You close on the property, and now you've got to asset manage the whole thing and basically run the whole thing soup to nuts. So that's usually not an issue if you're the syndicator. But when you start bringing in other people who start to look more like they're really brought in to raise capital, then that's one of the prongs that they're going to start to look a little fuzzy on, which is, what are they actually doing in addition to raising capital? Because they've got to be doing substantial duties. And I know that, and I recognize it's very nebulous, and we don't have too much guidance. The best way I can think of substantial duties is just doing whatever. Just think of all the things you do as a syndicator. There's probably a list of 50 things or 30 or 40 things you do. And so the more of those things that everybody has to do, the better you are in terms of categorizing that as substantial. And you can look at it as a percentage of, well, how much time are you actually spending on real work for the LLC, for the deal, and how much time are you spending on raising capital? So that's another way you can kind of think of it. And that kind of goes into the third prong, which is your primary role, primary responsibility needs to be working on those substantial duties and not raising capital, right? So it has to be, in my mind, 50% plus 1. So that one's actually a pretty easy prong. To me, the first and the third prong are the easiest, right? Transaction-based compensation, that's very simple to figure out. And then the primary one is very simple, because it's just, how much time did you spend raising capital? How much time did you spend once the capital was done raising, and now you're actually running the company? What are you actually doing? How much time are you spending on those things? And as I always say, all of the co-sponsors don't have to be doing the exact amount of work. Just because you have 3 people or 4 people doesn't mean that I have to be doing 25% of the work in order to be a legitimate co-sponsor. There are plenty of co-sponsors out there that have full-time jobs, that work on weekends and evenings. The example I always love to give is, it's not uncommon for somebody to be brought in who's really good at underwriting, and so they spend some time on the weekends and maybe on the evenings, looking at different markets or looking at different properties to sort of expand the reach of the underwriting. And so if that person is only working weekends and nights, then they may only be getting 2, 3, 4, 5% or 10% of the GP, because they're not spending all of their time on it like maybe the lead sponsor. So it doesn't mean that the sponsors have to be doing a tremendous amount of work, but they do have to be doing substantial duties. And to me, it's, again, sort of a sliding scale situation. This is all facts and circumstances, which is, by the way, another reason this is kind of frustrating for many, because there's no one answer fits all. You're going to look at the specific facts and circumstances of a particular situation. And so the example I just gave, if somebody's spending, weekends and nights underwriting and they're getting 2% of the GP, well, that's great. And if they, incidentally refer a couple of people or a couple of buddies or people that they know into the deal for, a small percentage, that's probably not going to be a big deal because they're spending all their, even though they're not spending a lot of time, they're spending most of their time doing the underwriting. But if that person's underwriting on the weekends and evenings, and they're getting 40% of the GP because they're bringing in $1 million or $2 million of money, then that starts to sort of, the story starts to kind of fall apart a little bit. So that's kind of how I look at substantial duties, just because we just don't have too much guidance from the SEC. We have guidance on transaction-based compensation, and obviously the primary is pretty straightforward in terms of time. But the key to all of this is just to make sure that there's some active participation after the fact. So once the deal's done, not the deal's done, once the offering is done, meaning you've raised all the capital, you've closed on the property, what exactly is everyone doing? And so, to answer the specific question, which I guess is the way I phrased it at the beginning, which is, well, how do I specifically do this? How do you legally incorporate money raises? Let's work through a couple of best practices. First one I've already mentioned. Let's not call anybody a capital raiser. One of the things you should always remember, that all of the communications that go back and forth between all of the co-GPs or the co-GPs and whoever the parties are, those are never privileged, right? So I've seen emails going back and forth between the co-sponsors where they're negotiating the percentages, and inevitably there's references to money raising, or hey, if you bring in this much money, I'll give you this much of the GP and all that stuff. That's not going to be privileged. And so if there ever is an opportunity, or not an opportunity, if there's ever an audit, if there's anything that's becoming an issue, then all of those communications are going to be discoverable, and the SEC or the regulator is going to get their hands on it. So again, avoid all those communications, even discussing that. And then I've also seen a bunch of spreadsheets on the underwriting side where one of the tabs will include, hey, here's the percentage for the person who found the deal, and here's a percentage of the person who's doing this. And then not inevitably, but a lot of times you'll see a little line item on the spreadsheet that says, hey, we're going to pay 15% to the capital raiser. And again, that's not going to be a privileged communication, which is probably another reason why you want to get an attorney involved early and just make sure you're copying the attorney on all these communications. Maybe that'll cloak that communication. But by the time that happens, it's usually a little too late. So first best practice is to make sure that you don't call them capital raisers. And number two, another great practice would be to outline ahead of time what exactly everybody's role and responsibilities are going to be, and then what the compensation is going to look like. And when I say compensation, it's really percentage of the GP, or maybe how you're splitting the fees that are going along. But if you can document that early on in the process, theoretically, even before you've gotten into contract and actually, well, let's just say it this way, before you started the process of reaching out and starting to raise money, if you can document that in some kind of nothing fancy, maybe it's a, sort of a letter of intent or a memorandum of understanding, or just some working document that everybody kind of signs off on, preferably notarized, because then there's no debate, maybe, that it was done after the fact. But now you have a document where you can clearly show that, hey, there's 4 or 5 of us. Here's what all of our duties were meant to be at the beginning. Here are the percentages that we all agreed upon, and that hasn't changed. Another place could be actually the actual operating agreement of the management company, the GP operating agreement. If you outlined all the percentages ahead of time, signed it, then there's no debate that you were getting compensated based on the amount of money that you are getting credit for, or anything like that. You're actually, getting paid for these duties. Another thing to keep in mind is that it doesn't matter, just like a lot of things with AC, it doesn't matter what you call things. So it doesn't matter, it helps, but it doesn't really matter that you've outlined, all of the duties in a document. What matters is that you actually do those duties, right? So at the end of the day, if this ever got to a point where somebody's auditing, then you're going to have to be able to show that, yes, I attended these meetings and I contributed to these meetings, or I flew down to the property, or I met this, or I did that, whatever it is that you're claiming was your duties pursuant to some agreement, that you can actually show that. I think the burden of proof is going to be on you. And so the more you can show that, the better you're going to be. But so that's probably, again, best practice number 1 and 2, I guess, is don't call them capital raisers. And number 2, in order to avoid any perception that you're getting paid transaction-based compensation, which is probably the big one, just have some kind of an agreement ahead of time, so nobody can come back to you and say, no, this compensation was based on how much money was brought in. The third thing, another way to sort of make it work is, and this is going to be a tough one for some of you to take in, but limit limit the amount of co-GPs in the deal. I mean, the more people that are on the co-GP team, the harder it's going to be for you to show that everybody is substantially involved, or that at least one of those people is really primarily there to raise money. I'm not saying it's impossible to have multiple GPs, but I'm getting to the point where now I'm seeing some deals that have literally 8, 9, 10, 12 co-GPs. And so it's not impossible. I'm just saying it's harder and harder to argue that all 12 of those people were substantially involved. I mean, when you think about it, I don't know. I always joke 2 or 3, 4, maybe now 3 or 4 years ago, it was more common to see you always had partners, but it may be 2 or maybe a third, three GPs. Maybe it's the main lead sponsor, 1 or 2 sponsors, then maybe somebody that's boots on the ground that's specific to that market. But it wasn't something that I would always see all of these different, 6, 7, 8, 10 GPs. And so that's another thing that you can try, and we would certainly strengthen your case if you had, 3 or 4 GPs as opposed to 8, 9, and 10. But at the end of the day, it's just kind of common sense, I would say, in the sense that you want to make sure that everybody in the GP team is actually a real syndicator. They're actually doing the work like the lead sponsors and what you think of a syndicator. There's so much work that everyone's doing. The more work they can actually do, the less there's going to be any kind of allegation that they're raising money. So I think that's kind of what I wanted to talk about. Like I said, I always like to keep these to, I think I'm right on track here, about 15 minutes. And so again, the point of this whole live is for you guys to ask specific questions. This is content that I put out pretty regularly, so I want to make sure that I'm addressing your specific questions and specific needs. And I am going to go through, since I don't have my amazing Bethany to help me out here, I'm just going to go through these. For those of you who haven't been on this before, what I like to do is I go through and answer the Q&A that's specific to the topic. And then once we get through all of those, then I open it up to just, anything, whether it's this topic or not. So let me go through this. So hi, everyone. Thanks to there's 85 people on this call. So thank you. Michael, hey, from California, currently syndicating. Great, Michael, thanks. All right. So, hey, Jared, let's get you on there right away. Let's go, Jared. Let's ask you questions about the 1099. I think that's a good one. Unmute yourself, Jared. If you're here, are you still here? Maybe Jared came on.
Sorry.
There he is. Yeah, you're good. Hey, Jared, how you doing?
Good. How are you guys?
Good. Go ahead and answer your question, because I think it's a relevant one, because this is I briefly touched on it, but
yes. So you were talking about employees, and I'm assuming you mean a no kidding like W-2 employee that you pay taxes on, all that standard stuff. But what about if you have 1099 people on your team and stuff like that?
Yeah. So the term that we use is really anybody that's an associated. Just mute here and we can an associated person. So it doesn't have to be a W-2 employee. It could be agents as well. I probably should have said that when I made my presentation. It's any agent of the issuer. So a 1099 contractor would certainly fall into that category. That in fact, I would argue that a 1099 contractor would be more likely to be considered a capital raiser than an employee, because an employee, the key with an employee is just to make sure that the capital raising activities is incidental to into their normal duties. Again, same thing, spending more of their time on their substantial duties. So the employee is going to have some duties anyway. And if part of that is raising capital, that's fine. If they're spending 10, 20% of their time on it, as long as they're not getting compensated for that raising, or even getting bonused. That's another thing people try and do, is bonus their employees in such a way that it basically ends up being transaction-based compensation. So you got to be super careful there. But Jared, it doesn't matter if they were a 1099. To me, that's still, not to me, that would still be considered an associated person, and we'd have to go through that analysis and make sure that you're not paying them transaction based, that they're actually engaged in substantial duties, and that their primary role was doing those substantial duties and not something else. Hopefully that answered your question. And if not, you guys can always just pop in there to follow up here. Rick, this is one of my favorites. You got the Rick Gisler. Do you want to unmute yourself and ask your question?
Yeah. Hey, Mauricio.
Hey,
so I was just curious about, if you're going to try and verify or justify a capital raiser's additional significant contributions, let's say we bring them in and they continue to maintain investor relations. In my mind, if they're going to be part of that significant raise that helps you acquire the property, would that still qualify as a significant contribution of maintaining long-term investor relations, whether that's sending out the weekly or monthly reports and things like that?
Yeah, so that's obviously a very, it's a great, I'm going to spend a little bit of time on that because this is something that comes up a lot, and whether being an investor relations alone is good enough or not. Now, obviously that's a task that you're doing post-close. So it's obviously part of sort of the asset management or the project. So from that perspective, it's good. Again, it's all facts and circumstances, no black and white answer, but let me give you some examples of things that would not qualify, and then maybe we'll move along the spectrum where I think you're getting better and better. One that I think would never qualify is when you have situations where you have 3 or 4 investor relations, because everybody's is sort of the contact person for the specific investors that they brought in. And that happens quite a bit. So you have multiple co-GPs, they're all responsible for bringing in a certain amount of people. And then they're the ones communicating just with quote unquote, their investors. Again, I put that in air quotes because there is no their investors, your investors, my investors. It's our investors because it's part of the, the syndication LLC, and we're all contributing to that. So if that's the scenario where you have multiple investor relations people that are communicating different things to different people, I would say that's probably not going to cut it. Similarly, if by investor relations, you're simply, sending out the email, somebody else prepares the email, somebody else does all the work, and you're basically just sending out that communication at, once a quarter, what have you, or spend very little time. Maybe you're just crafting the email or something. That obviously wouldn't work either. Where it starts to get interesting is if you, number one, are again, sort of the legitimate investor relations person, meaning every time an investor has an issue and calls the company, you're the one that actually is in charge of housing that call and addressing the issue and getting the investor whatever documents they need, or answering any questions, or getting those questions. That would be a start. And then when it comes to the reports, are you the one that's actually preparing the reports? So if you're the one putting together your quarterly report, trying to figure out what all the numbers are, trying to figure out what the distributions are, and really, solidly involved in that, then that's certainly going to help you. But then the question would be, how much are you getting compensated for that? Because if you're raising a ton of capital and that's all you're doing, and you're getting a significant portion of the GP, there's an argument to be made that, you can go get an investor relations person for 60 grand a year, 80 grand a year. Why are you getting paid 200, 300, 400,000 to just be an investor relations? So I did hear through the grapevine, and I'll say this here, although it's sort of unsubstantiated, and it was probably at a the staff always has these events that they do. But one of my colleagues, attorneys, had mentioned that one of the staffers had taken the position that being an investor relations alone wasn't going to cut it. But I haven't been able to find anything, in writing or any source for that. So I'm guessing it was some sort of a panel that they were on. So that's just, I get nervous when it's just investor relations. I would try and add as many duties as possible. So if you guys are having asset management meetings, or if you're meeting with a property manager once a week, once a quarter, if they can participate in those calls, that would be helpful. And not only just show up, but actually, contribute, right? Actually give your opinion and try and persuade the conversation. So again, the more you can do, the better. But investor relations is probably the number one way people try and squeeze that in there. And if it's a legitimate investor relations, I think you've got a shot, but the more, the better. Hopefully
awesome. Thanks.
Thanks, Rick. If you, Mathieu, do you want to answer that question? I'm not sure it's close enough. Let's go with that. I know you're in Canada, so let's get some Canadian questions.
So any specific rules as a Canadian using capital from Americans that we have to kind of be different, or it's the same, we're treated the same way from Canada?
Yeah, I don't think, it's an interesting question. If you're Canadian, it starts to become an issue if you're putting together fund of funds, if you're sort of an investment advisor, then it starts to become an issue, or some issues, not an issue, but things you got to think about. And similarly, if you're, if you got in passive investors from Canada, there's a lot of issues we want to think of. But if you're a co-GP, and you're not getting paid transaction-based compensation, and you're doing substantial duties. I mean, I have several Canadian clients, and they're the lead sponsors, and they're doing all the work, not all the work, but a lot of the work. And we don't have any issues with here. Now, the only potential thing I can think of is, obviously, I'm only worried and concerned about the SEC and the regulators here in the United States. So Canada has, as you know, a very robust securities laws. And so we just want to make sure that you're not violating anything in terms of rate when you're raising, if you're raising some of the capital in Canada and you're doing meetings or whatever as incidental to your, as part of your, not your substantial duties, but you're doing, obviously you're helping with the capital raise, making sure you're not violating any of the rules up in Canada. But from the SEC or the state regulators are concerned, I don't think there are any specific issues with Canadians in terms of just falling within this exemption to being a broker dealer.
Thank you.
And I guess one other thing I would add is, again, I didn't thought of this either, but making sure that you're not going to be, we're talking about not being considered a broker dealer here in the US. You might, want to make sure you're not violating broker dealer rules out there in Canada as well. All right. Thanks, Mauricio. Good seeing you. Kuna, I will talk about that. I'll talk about that after I go through all these questions to make sure that I'm not missing any. Tim, it's a clarifying question. So I'll ask for you. So Tim asked, what was the third key? I have written no transaction-based compensation and a need to have substantial duties. Yes. And so the third one is that your primary role needs to be those substantial duties vis-a-vis raising capital. So to me, that's an easy one because it's just, for me, that's 50% plus one. So making sure you're spending most of your time, 50% plus one, on those substantial duties versus capital raising, which is one of the reasons we really focus on what are you doing after the deal closes, right? If the deal closes and then you're done and you're not doing any more work, it's going to be harder for you to show that you are involved in substantial duties and you didn't spend most of your time raising the capital. But that's the third one, Tim. Ben, my troublemaker. Ben, I haven't even read this, but Ben, you want to unmute yourself and ask it?
Sure. Hi, Mauricio. So
Good.
This is
we just want to hear your accent is really the reason I put you on there.
This is something I was thinking about a few months ago, co-GPs, and because I remember you talking about this before. And there's a really large, well-known syndicator, well over $1 billion assets under management, $1 billion that I've invested with. And I thought, let me go back and look at the PPM and see how he structured it. Because I know this guy has a large number, I don't know how else to call it, capital raisers. I don't know if they're co-GPs. I don't think every single one of them is putting together an SPV for its underlying investors to invest like as an individual investor. And I just wonder if there's another way this is being structured.
I think I know where you're going with this. I'm just trying to be as careful as I can saying this. So I started, and not just me, I don't want to be like, oh, I'm out there the only one talking about it. A lot of my colleagues that you guys know well, and maybe some of your attorneys, we've all been talking, we're all on the same page. So a lot of us have been banging the mat about this issue because it is, it has become kind of just a big deal. I was going to use the word pandemic. It's like what's the word I use? I forget the word, but anyway, it's become a major issue where not everyone, but a lot of people are doing it. And we really started pounding the pavement about 2 years ago, or maybe 3 years ago, pre-COVID, because the SEC opened up investigations on what you just described, Ben. And they were targeting large syndicators and syndicators that are well known. And probably if I'm not going to, but if I mention their names, you would know who they are. And so I always felt that this would not be an issue until the market turned, or that they're, didn't even have to turn if it just kind of leveled off. And because none of this is an issue when everything's going great, right? And we had such a great run. And so my thesis was always, hey, when things start, inevitably, whether it's 20 years from now or 10 years from now or next year or next month, when there's a slowdown, that's when the issues are going to come up, because there's always people who bought at the top who then can't perform. And so investors become unhappy. They pick up the phone, they call the SEC, they call the regulators, they open investigations. That's how it kind of starts. But this happened pre-COVID when things were still going really well. And they opened up investigations, and there's at least 2 that I know of. Maybe some people here on the call, a lot of passive investors and syndicators got letters from the SEC subpoenas back then, sort of requesting that they don't destroy documents. So the SEC is aware of this, and they're actually targeting this quite a bit, especially some of these state regulators, which is usually where they come from. But these were SEC investigations, Ben. And the reason I'm bringing this up is just that I guess the reason I bring this up is just because you see people doing it out there doesn't mean they're doing it correctly. And this comes up in a lot of other topics, right? Social media advertising is another one. Everybody's doing it. And this is probably one of them too. That's a pushback that I get a lot of times. And I know it's super frustrated because you do know other people who are doing it. And it's kind of like an unfair advantage if somebody else can presumably go do this and not be an issue. The amount of emails that I get, I'm on a lot of people's emails list, the amount of emails that I will get where they're offering their services where, hey, I can bring capital to your deal. And if I bring this much capital to your deal, I'd like to get paid this, a percentage or whatever, clear violations of the rules. But the SEC came down hard. Well, SEC came down. They opened an audit investigations. I think they've got resolved. They sort of settled their way out of it. But those were not doing things properly. And that was what the SEC was targeting, that they were actually raising capital without having a broker-dealer license. So it is prevalent. I wouldn't even say it's rare. I don't want to say everyone's doing it, but a lot of people are doing it enough where you probably know people who are doing it. And so I totally sympathize that it gets really frustrating because a lot of people are violating the rules and they're not getting caught, right? And so that's the only thing that they've got going for them, because if they did have an audit opened up with them, they would be in a world of hurt. And paying unlicensed broker dealers has all kinds of issues, because for you guys, the syndicators, you're not disclosing that. Why would you? You're not disclosing that you're paying, an unlicensed broker an illegal fee, and so there's a failure to disclose issue right there. And then obviously I don't really care too much about the person coming in who's unlicensed, but just like, as I always say, you can't practice medicine without a medical license or law without a legal license. You can't raise money without a broker-dealer license. And so they get into trouble. Then there's usually restitution, fines, and they've got a disgorgement is what we call it, where you've got to return the money. So Ben, the long-winded answer to your question is it goes on all the time. And if you didn't see, and I don't know obviously which specific PPMs you're talking about, but it doesn't mean that because it didn't show up that somehow they're structuring it somewhere uniquely. The way around this really, in terms of, and we've talked about this, and maybe this is a nice transition into another question I had, but the easiest way around this, and maybe this is another way to answer the question from the topic of this live, is in addition to bringing in a legitimate co-GP, which is kind of the way I like to frame it, bring in a legitimate co-GP, not a money raiser. But if somebody's really good at raising money, then have that person create a fund, right? And there was a question up here, so let me just go back here about the fund of funds model from Kunal, who said, thank you for hosting. Would you please talk about fund of funds model? And so now that I think about it, Kunal, that is kind of related to this topic. And so the second way to do it, which is much cleaner than this, because as you can tell, this is very nebulous, and what does substantial duties mean, and it gets things. The easy way, I don't want to say around it because it seems like it's nebulous, but the easy way around it is to have that capital raiser be a true capital raiser and set up their own fund, raise the money into their own fund, and then turn around and invest it in other people's deals. Now, again, we've talked about this, I think, a couple of episodes ago. So if you haven't seen the live from, I think it was the second one, we talked about fund of funds and funds. You want to make sure that you're not raising money just for one particular fund, but you want to raise your own fund and to go invest in a bunch of other ones. But if you're doing it right, that would be a better way. If I'm really good at raising capital, instead of going and co-GPing with a bunch of different random syndicators throughout, 4, 5, 6, 10 times a year, set up your own fund, raise capital, add value to your investors by doing the due diligence and flying down to the properties and doing all this, negotiating better terms for your clients, and then raise money into your LLC and then go place money somewhere else. And that way you're getting compensated now for putting together your fund legally and not raising capital for somebody else. Great question, Ben. Thank you. Let's see here, Ben. Robert, you want to ask your question, Robert? I'm not quite sure I'm getting it. So Robert Friedman, just unmute.
What I was trying to find out is if you're raising capital and it turns out that a single LP wants to do the entire LP portion of the deal, do you have the same concerns that you would have if you're syndicating from a number of investors?
Meaning you've got the issue of multiple co-GPs, and one of those, if it's a single investor, then theoretically one of the GPs had that connection to bring it in.
Correct.
Right. So one of them has it. So if you've got 4 GPs, one of those people, so the same, it doesn't matter to me. It doesn't matter whether you have 1 LP or 1,000 LPs. The issue is the co-GP getting compensated to bring that investor in, right? And if they're getting compensated for bringing that investor in, purely for bringing that investor in, you've got a problem whether it's 1 investor or 10 investors. So you want to make sure that they are, they're what we just talked about, all the thing. I don't want to be repetitive, but yeah,
right.
so it makes no difference.
Yeah, the only thing that I thought might be different is that when you're bringing in a single LP who's getting, generally speaking, a majority ownership of the deal, it's more of a negotiated transaction with a sophisticated. You're creating a partnership versus selling. I'm wondering if it's a partnership versus selling securities, because that single LP in most scenarios would be the majority owner of the property.
Well, yeah, although in a typical syndication, usually the passive investors are well over the majority. A typical split would be 80-20, 80 on behalf of the investors. So it's a
right, but no single investor would have a majority.
Would have more.
Here.
Yeah. No, I think where you're going, which is interesting, is just to restructure that. So when I answered the question originally, I was just thinking of a usual syndication, but instead of having 30 investors, you have 1. But with one passive one investor, you could restructure that so it does look more like, but it could be restructured as a joint venture, because if they want to have more involvement, they want to have more say, have some veto powers, then most of the deals that I do that have something something along those lines, I would actually create a different structure. I would have them come into a different. I would be a joint venture. If it's 1 investor, I would probably structure it as a joint venture, and that way you could get around these things because you're no longer effectuating the sale of a security, because everybody's sort of actively involved. So there's
right.
probably a way to structure it. But if you structured it the same way a traditional, which by the way
right.
happens, happens all the time. There's just one, and usually it's a private equity group or something. But even if it's just
right.
one big whale, a lot of times we just structure it exactly the same. It just, instead of having 20 investors, we have 1. If that's the case, the same rules apply. But maybe there's a way to restructure that so we take it outside of the realm of securities, because again, broker dealer activity has to do when you're either in the business of effectuating a securities transaction for others. And so if it's not a securities transaction, then there's no broker dealer issues.
Yeah, that was my thinking. Thanks.
Yeah, of course. Michelle, I'm not sure if that's hey, Michelle, let me come back to that one. It's a great question though. Francis, why don't you ask your question? That's interesting. I mean, Francis, you want to answer that question? Unmute yourself.
Or not, I don't want to answer that question. I'll ask that question.
Ask your question.
Yeah, I feel like someone told me they did something like that recently, and I didn't really inquire into it. So I'm wondering if that's basically just setting up a fund, or if there's another way to set up an entity where the LLC is then investing in the syndication, or just what the best way to do that would be so that everything's above board.
So your question is, what if an LLC invests and someone raises capital for that LLC? That, I think where you're going is exactly what you just said. That sounds like a fund of funds model or what have you. And so, yes, that works. And I'll spend 2 seconds on it because I did it was almost a 2-hour thing on the second live. But yes, if you do a fund of funds, the beauty of fund of funds is that you're not getting compensated to raise money for others. You're getting compensated for, first of all, putting together syndication. So talking to, attorneys, for crying out loud, that's they should get compensated enough just for doing that. But putting the deal together, vetting the sponsors, so flying down to their offices, looking at their operations, you're basically vetting the sponsor, you're vetting the actual investment. So when they have a deal that you're thinking about investing in, you're going to get on the plane because your investors are busy. They don't have time. They're passive. They don't have time to do anything. So you get on a plane, you fly down to whatever the state is, you walk the units and you come back and say, yeah, look, I'm comfortable with this. You usually negotiate better terms for your investors, because when you show up with $1 million check, the syndicator is going to listen to you. And if you want discounts, typically it's a discount on your, maybe your acquisition fee gets discounted, or asset management fees get discounted, or maybe instead of a 70-30 split, it's an 80-20 split for your investors. So you're able to negotiate better terms. You're just doing all of these things that add value to your passive investors. one of the common mistakes I think in that model is like, if you just raise money into your own LLC and turn around and invest it in somebody else's LLC, that's just going to be what I call a disguised commission. That's just going to be you coming up with smoke and mirrors to get around the rules. But if you're genuinely adding value to your fund and putting together your own syndication and adding value to your passive investors, then that's a potential. Now, the other issue you have with fund of funds is in addition to worrying about the broker dealer rules, you've got other issues you've got to worry about, like, you are an investment advisor at that point. So do you need to register as an investment advisor, or is there an exemption? And that's going to be depending on what state you are. I know that you're in, I think that's the picture there, but you're in Hawaii. So I don't know what the rules are in Hawaii in terms of the exemptions. So there's a bunch of other, it actually gets pretty complicated from a regulatory standpoint. But yes, that is one of the ways that if you can figure out and you qualify and you have no issues with all those restrictions, then raising money into your own LLC first, and then turn around and invest it in multiple other people would be a way to not violate the broker dealer laws.
But it sounds like fund to fund. So I will look, I guess, back on your Facebook for the one you said you just did an hour or 2 hours on.
It's like 2 hours. I think it was our second live. I actually uploaded that up to YouTube. So if you look on YouTube, I think episode 2 is up there. I'm actually going to start uploading them. It's just too long to put them up there. So I'm kind of editing them down a little bit. So I actually created a Facebook group. So I'm going to start putting all of this raw stuff in the Facebook group and all the questions cut up and each question being its own little clip. So it'll be easier to digest. You don't want to have to sit through an hour and 45 minutes of a fund of funds presentation. You can pick and choose, what questions to look at. So, but I'll send you guys an email with the replays and everything.
Thank you.
Thank you. Emma, I think I answered your question because it's also a fund to fund. How much of this applies to fund managers in a fund to fund structure? So again, if you guys haven't seen that second, I realize that it's a really, and this is something I'm not struggling with, but I'm trying to figure out to make it easier for you guys. But the way I've tried to solve the issue right now is if you go back to the prior lives, and that episode 2 was on fund to funds. My presentation is like this. It's like maybe a 15-minute presentation. Maybe that one was a little bit longer, but then I actually timestamp each question. So you can actually, after you listen to my presentation, you can go look. I think there was like 28 questions on that episode. You can just look through the questions and see which one makes the most sense for you. And you can click on that particular question and just jump straight to the answer. But I would refer you to that fund of funds episode we did in episode 2. But thank you, Emma. BD, you want to ask your question? That's a lot of fund to fund questions, but it is kind of relevant to this because that's one of the ways that you can sort of not bring in capital raises, but where capital raises can solve their issues. BD, you want to ask your question?
Yeah, sure. Thanks. My question is related to fund of funds, and I guess there's a .3C1 compliance aspect to it, where if the management role of the fund of fund, the management LLC, not the actual fund of fund LLC, gets incentives, we're supposed to disclose that to investors in the fund of fund.
First of all, anytime you're talking about compensation and incentives, you should be disclosing that to investors. And if you're ever in doubt whether to disclose or not, you should err on the side of disclosing it. So from a disclosure standpoint, I think you were going somewhere else with 3C1. I'll talk about 3C1 briefly, but yes, anytime you have any additional incentives or extra payments that are going hopefully to the actual fund itself, those need to be disclosed. One of the what's the right word? One of the things you want to be really careful about when you do the fund of funds is all of the additional So when you do a fund of funds, you can negotiate better terms for your fund, and you should. That's one of the benefits that's what private equity groups do. You come in with $1 million, that syndicator is going to listen to you. And so you can negotiate either better financial terms or maybe more, veto power on some decisions, or being on a board, getting a board seat. I mean, whatever you can negotiate that benefits your investors, you should do that. But oh man, I lost my train of thought. So any of that stuff you can do. What you cannot do is, I don't want to say on the side, but as a fund manager, get compensated directly for bringing in that money from your fund to somebody else's fund, because that now you're getting paid to raise capital. You're actually getting an incentive or a compensation for bringing in that capital. So any additional compensation or any additional incentives that you have negotiated for your fund need to be paid to the fund, not to the fund manager, you individually, because again, that's just going to be a commission. So everything has to flow neatly through the fund. The fund gets more revenue because you negotiate better terms, and then you take your cut, your carried interest, your asset management fee, whatever you're taking based on that additional revenue. But don't skip that step. And as a manager, say, look, I've got a fund. I'm going to invest $1 million in your deal. And oh, by the way, I also want to get paid. I want 2% of the GP for bringing this capital in, because that's going to violate broker-dealer laws. You mentioned 3C1. That really has to do more with the Investment Companies Act. To go back to Francis's question earlier, another issue you have with fund of funds is you're a passive company. You're really just an investment company. And so you want to avoid having to register under the Investment Companies Act, because that's a whole other world of regulations that you don't want any part of. And the easy way around that is if you're a 3C1 company, which means your fund has less than 100 investors. And I also did a video on that, on the 100 investor rule. But yes, anytime you've got any compensation, at a minimum, you want to disclose it. But in that particular case, you want to make sure that you're not taking any, as the fund manager, you're not taking any additional compensation, because that's going to look like broker-dealer laws.
Wonderful. Thank you, Mauricio.
Yeah, thank you, BD. Next question. A lot of fund of funds. Let me see if there's any specific broker here. Dante, not quite following. Dante, you want to ask a question?
Yeah, Mauricio, thanks for putting this on. And
yeah,
thanks
of course.
I mean, appreciate it.
Always.
So as we're building up our track record, we're starting to talk to some private equity firms that are looking to do, you talk to the individuals like CBRE, Franklin Street, and they have individuals that will do debt and equity. So they're going to do equity placements for us. They go out to an individual, write a single check for our LP portion. Are those, and we compensate them for bringing that check to us. Are those guys considered brokers? I know they're debt brokers, but are they going to be considered equity brokers as well? Is there any issues on the syndication realm if we have them come in and raise that capital for us?
So you're saying they're debt. When you say they're debt brokers, you're meaning they're commercial. They're the lending broker. They're the commercial lending brokers.
Correct, right? But they also have access to do equity placements and deals as well.
Yeah, I mean, those are different. When I say broker, I'm not talking mortgage broker. I'm not talking real estate broker. I'm specifically talking broker, a FINRA licensed broker dealer.
Right.
And so that, from what I'm hearing anyway, unless maybe they are licensed that way, but they would have to have that additional designation. If they're just a mortgage broker, then they've got a license to get compensated to, basically they're out there finding a lender for you. But if they go find an individual private equity group, I don't see how that's any different from, now they're getting compensated for the placement of a security. So I would hope that they have some kind of a broker dealer designation, or somehow they've got a broker dealer in there somewhere, because that to me sounds, the way you've described it just sounds to me like broker dealer activity.
Right. Okay. Yeah, that's what I figured. Because have you heard of groups like George Smith Partners, Franklin Street, all those guys?
No, but a lot of these guys are brokers. So I'm not saying that they're not brokers. There's a lot of platforms out there that place capital for you, but most of those are broker dealers.
Okay. Yeah. Just want to make sure it's not like a different type of exemption you'd have to have if you brought on one individual like that.
No, I'd be careful that. Obviously the mortgage broker is in the business of finding a lender for you, and that's what, and right. they do get paid a percentage, but if they're finding equity, they would need a different license for that.
Awesome. Thank you. Appreciate it.
Of course. Thank you, Dante. Brad, you want to ask your question, Brad, or is that kind of tongue in cheek?
No, I think there was only two states in the U.S. We were talking about fund of funds quite a bit here, and isn't there only two that you can't do fund of funds? Like if we wanted to partner with somebody and raise capital for them, I can't do that because I live in Washington State.
Yeah, no. So it's not. That's where I was thinking. So it's not that you can't do it. So just as a recap, when you do the fund of funds, where Brad's going is that you are an investment advisor by definition, because you're in the business of advising. The way they look at it is, in Brad's case, Brad is advising his fund as to the purchase of securities, which is somebody else's fund or somebody else's syndication. That's why you're an investment advisor. The follow-up question is, do I need to do anything about it? Do I need to register as an investment advisor, or is there an exemption to registration so I don't have to do it? And I think every single state, and no, I came across one actually, and I can't remember which one it was. Maybe it's Alaska. But every single state that I've seen, except for this one, has an exemption it's just a question of how onerous that exemption is. And so Brad, since you mentioned it, I'll share, Brad happens to live in the great state of Washington, and Washington does have an exemption. The problem is the exemption limits you. You can put together your fund of funds, but all of your investors need to be qualified individuals or qualified purchasers, which means they have to have a investable liquid assets to invest of $5 million, which basically blows the whole thing out of the water. So it's not like you're prohibited. It's just that, it's so onerous that the way they've structured the exemption is basically you've got to register. So you're, as we've talked about, I think you've got two options. You either register as an investment advisor, therefore you can then do your fund of funds. At least you satisfy that prong, or you move. You move to a different state, right? And so but it's not that you can't do it. It's just that the exemption's really onerous.
Gotcha. Thank you.
Thanks, Brad. Good seeing you.
Likewise.
Oh, I thought Tom, I was looking at Tom. I thought you said if you kind of went south, meaning south of the border. Tom, you want to ask your questions if things go south, meaning something goes wrong, not that you're going to escape to the south. Tom, you want to ask your question?
Yeah, I mean, yes, south, not south of the border, just south figuratively. I mean, what are what are the risks we're talking about here? I mean, worst comes to worst, all those things you're not supposed to do, you do, then the deal fails and the investors get angry and then the SEC starts breathing down your neck and they find evidence and it all goes south. What actually happens?
Yep, great question. Yep, great question. So let me walk you through what'll probably happen. I don't know if this is maybe helpful for other people too. So typically, although on the example we were given before, for those large groups that got sort of under the investigation of the SEC, I don't know how they figured it out, if it was tipped off or something, but we actually had SEC people actively looking for them. So typically, though, it happens when things go south, as you mentioned, Tom. So an investor typically initiates a complaint. Usually it's a state regulator, not the SEC. SEC's understaffed. They've got a lot of other issues going on, and the states are kind of bored because they've got nothing to do. And so it's usually the state regulator that will open up the audit. And what'll happen is you'll get that letter from the regulator saying, hey, they don't exactly give you too much details, but somebody complained. So let me see all of your docs. Let me see all of the stuff. And usually that's good enough. But if you have been violating stuff, they'll bring you in for deposition. They'll do a whole investigation. And at that point, usually if they want to move forward, they could file lawsuits, obviously. But in something like this, most likely you'll end up negotiating a settlement. But if you didn't want to negotiate a settlement and you were like, no, I didn't do anything wrong, I'm going to take this to the end and I'm going to fight it to the end, then eventually there would be a lawsuit brought. And if you lose that lawsuit, the issues for you as a syndicator are no different than the issues you would face if you violated sort of the social media, for example, advertising, in terms of, you've blown your exemption, now you've got an unregistered offering. The same thing would happen here. For the syndicator, you'd have an illegal, uncompliant offering for first and foremost. And so your investors' remedies would be restitution, meaning you would be giving all of the investors' their money back, plus interest, irregardless of whether it was caused by anything you did from a mismanagement standpoint. So if the economy collapses like it did in 07, 08, or whatever, you wanted to refinance and the financing dried up, even though it theoretically wasn't your fault, the fact that you have a non-compliant offering makes you at fault and you're in violation of those rules. So restitution is usually step one. Give your investors money back plus interest. So I always joke, you're kind of guaranteeing your investors money at that point, because even if they lose money, most likely you don't have the money. Although in this case, it may not have, because it's going, I guess you said it goes south. So usually what happens when things go south is there is no money to be had. Like if you raise $5 million and you've got to return $5 million plus interest, you may not have that. And so a lot of times you end up filing for bankruptcy, which is another issue that comes up. And then the other thing that will happen, in addition to penalties and whatever fines they're going to give you, is monetary fines. They're going to bar you from raising capital in the future, whether that's a lifetime ban or a 5-year ban. Again, usually it's negotiated. And unless you're committing, obviously if you're committing fraud, it's a Ponzi scheme, it's probably a lifetime ban, something like this. Again, you typically would negotiate it, but I guess if you went all the way to the end, it would be a little bit harsher, but you would be banned from raising capital, certainly in that state that's opening it for some period of time that they, and again, you typically negotiate that stuff. Maybe it's a 6-month stuff if you negotiate it, but that's really what's going to happen. You're not, I wrote that book, The 5 Things Every Syndicator Must Know to Stay Out of Jail. I don't think you'll be going to jail for something like this because Again, that's usually reserved for fraud and sort of intentional wrongdoing. But it is serious. I mean, restitution, bankruptcy most likely, and then being barred from raising capital in the future. And then, of course, if you're the unlicensed broker dealer, then it's just what we call disgorgement, which means you've got to return whatever compensation you receive, plus interest, plus penalties. And again, most likely barred from ever, quote unquote, raising money for other people. So those are kind of your sort of worst case scenarios. In terms of the key, I see the follow up here. In terms of the key principal partner, I don't see the key principal as a money raiser. So I don't have any issues if assuming that they're limiting their activities to a key principal essentially is signing on the dotted line, basically leasing out or renting out their balance sheet and liquidity, and getting then a percentage of the GP in exchange for that balance sheet. They're not really, as a pure key principal, they're not raising capital. They're not bringing any capital. The minute they start bringing in capital, then that's different. That now we're talking about them as the co-GP, other than their capacity of key principal. But if somebody's a key principal, they're just lending their balance sheet, so that's not going to be an issue. And your last question, the capital raiser that didn't do anything else, then in that case, that's going to be that's going to be textbook. Then if they didn't do anything else and just brought in capital, then they're obviously not doing substantial duties, not doing any duties, and they're certainly not spending more time on those substantial duties. So that would be the violation.
Sure. And just while I have you, kind of a follow-up question.
Yeah.
Is there any difference between a 506B and a 506C for all this stuff?
No. Makes no difference. It's got nothing to do really with the exemption. I mean, those are obviously a whole new set of regulation. No, this has to do with the broker dealer side of the law, not on the Reg D and that side. So there's no difference whether it's a B or a C.
Got it.
Let's see here. I'm going to just keep going down here then in order. Well, actually, you know what? Let me go back to the top here because I want to make sure I didn't miss anybody who had another random. No, I think it was Kunal, but we answered that because I think it wasn't relevant. So Ben, we got that one. Oh, Gail. That's a long one. So I didn't read the whole thing. Gail, you want to ask yours? Or you want me to read it? If she's still here, Gail. Gail said, hi, Mauricio. If we want to get involved and create our own hedge fund to work underneath our syndication to help raise the funds for our real estate syndication, is there anything I need to know? Is that you, Gail, or?
Hey, Mauricio.
Hey, Gail,
yeah,
how are you?
Thank you.
Yeah, go ahead.
I'm good, honey. How you doing?
Good. You want to ask your question or just rephrase it to, because are you talking a hedge fund or you're talking sort of just a real estate fund?
No, I'm talking a hedge fund. I'm using a hedge fund creator, okay, which I just found out about. I have a meeting with them on Friday for another. I'm working on the ERTC funding through the government to provide businesses with the funds that they qualify for and they don't really know they even can get. But I want to utilize them to create a hedge fund for syndication projects, down the line, but I don't know if that's allowed or not. I've studied a lot on the hedge fund stuff, but I've been out of, not hedge fund, on the syndication stuff, but I've been out of the loop a little bit for a few years. So I don't want to make a mistake and hire them to do something they really legally can't do for us.
Yeah, I'm going to have to punt, Gail. I'm sorry, just because I don't really deal with hedge funds or venture capital funds. I just deal with real estate funds, and then hedge funds have their own. If we're talking about a legitimate hedge fund, and we're not just talking vernacular, then they've got their own licensing stuff, and it's just not an area that I practice in. So I don't mind looking into it for you and shooting you an email, but off the top of my head, I wouldn't be able to answer that.
Okay, no problem. All right, so I'm going to talk to them Friday, and then I'll get back to you.
Yeah, just
Thanks
shoot me an email. I'm happy to look into it.
That sounds great.
Goes for everyone.
Thanks so much.
Absolutely, Gail. That goes for everyone, by the way. If you've ever got a question or something, it'd be great for you guys to show up here. But if you just want to show up, shoot me an email. Happy to look into it.
Sounds good. Thanks.
Thanks, Gail. Brad, Tom, Ben. Ben, there's a link there. I thank you, Ben. Emma, you want to answer your question, Emma? If you're still there, Emma?
Yeah, I just have to get off mute for a second.
Actually, let me. I'm gonna mute you and then unmute yourself. All right, go ahead and unmute yourself, Emma.
Yep, we had
Got
some.
it. Perfect. Thanks.
Yeah, no, I was just curious, when you're looking for substantial duties, let's say you're raising capital for a deal and you talk to them like, hey, I'm not bringing in capital unless I have substantial other duties. Does that all have to be in asset management, or could it be like, hey, I'll be a KP, I've signed on agency debt, or I can do other things. I hate asset management. I don't want to be substantially involved. So what other options do we have?
I mean, the KP was nice because, you know, you can get compensated a percentage of the GP to be a KP, and you've got some more leeway. But honestly, if you're in the business of raising, you just cannot get compensated. I mean, your options are to go get yourself, probably the easiest thing would be to go get yourself an investment advisory license, become a registered investment advisor. And then, which I know that this is not a great answer for you because it's not something you want to do, but but actually some people have taken this route. So let's talk about it in a second. So the other way to do, because you're raising capital, you're getting, the way you described your question, you would be getting compensated to just rate. You don't want to do asset management. You know, KPing is interesting, but that's not really any activity. So then the question is, what are you doing, right? So KPing is, that's great. And so you're going to get compensated for the KP part. What else are you doing? And if you're not doing anything else other than raising capital, your options are, number one, he says you're raising a lot of capital, which means you have a good, you know, you've got contacts and you've got a good ability. Think about the fund of fund model. So raise your own funds, and then you don't have to asset management, because then you raise money into your own fund. You already have relationships with other operators. You vetted them, you do the research, and then you write a check to those guys. And then you don't have to worry about asset management anymore, other than just kind of checking in once a quarter. That's option one. And then what some people have done, and some people I know you guys know well, that they've gone out and gotten their become a registered investment advisor, and that's usually a state issue. Again, you still can't get, as a registered investment advisor, you don't actually get compensated directly, but you, just like a real estate agent, you hang your license under a broker dealer, and so now you get compensated because the broker dealer gets the fee, which is legal, and then you split those fees with the broker dealer. I understand that's not the most ideal thing. So I think for you, Emma, is like, realistically, I would, if you're raising a lot of capital, I would look into starting your own, you know, basically your own real estate fund, your own private equity fund that you can raise a bunch of capital into, and then go find operators that I know you know, and invest in their deals.
Okay. Yeah. Specifically, I have that club model that's kind of.
Oh, that's right. Yeah, we talked about the club. Yeah, it's a whole other. Yeah, we should talk about that offline. Yeah. I forgot about that. But thanks, Emma.
Thank you.
Francis is back. Do you want to ask it? It's just easier for the replay, Francis, if you ask it.
Yeah, absolutely. Happy to. And thank you again. So just the question of, if I was going to do a fund to fund model, is that fund at all part of the GP team then, or is it just totally separate?
You know what's, yeah, that's a great question. One of the ways actually you can get around this whole not the fund of funds, one way you can get around the investment advisory rules is that you could have your fund be a co-GP into the underlying syndication. However, in order to be a legitimate GP, that means that fund is actively involved, which you may not want to. You may just want to be raising capital and then just writing an LP check and going home and having the operator do all the work. But if you want to roll up your sleeves and your fund became not only the LP, but also a co-GP, well, now you're not really a passive investor over there. So you're not really an investment advisor, because you're not in the business of purchasing securities down there. You're actually actively involved down there. I don't know if that specifically is your question, but it triggered that, because we have done that before. If the issue of investment advisory becomes tricky, we can make your fund part of the GP. But again, that may not be what you wanted to do. So the question is, can you be a part of the GP? Oh, when you say part of the GP team, do you mean you individually, or do you mean your fund?
I guess either or. I don't know. So
yes, I would say it's okay to be. In fact, that might be one of the things that you negotiate. You know, on behalf of your investors, say, look, I'm gonna write a big check to this other fund, but I've negotiated, you know, a seat on the board of directors, or in this case, the equivalent of that would be, you know, a co-GP. The key is you can't get compensated in GP shares, you know, just for bringing the capital. So that's going to be the tricky part. But you can, so I would actually maybe not even call it a co-GP team. When you see the team, I would say I would be part of the, again, kind of like the board of directors. So you'd be part of the making decisions, but not necessarily getting compensated. Think of it as a part of the GP with 0% interest or something, or some negligible piece. So you're not actually getting compensated for that. It's just part of the value add, because now you're involved in decision making. You're in those meetings. You're in those asset management meetings. You're making sure your interests are and the interest of your investors are taken care of.
Would there be a potential from a previous question if, say, my fund was the solo LP on a deal, then it's more of a joint venture with, say, my fund and a GP or two other GPs?
Yeah, we've done a few of those. And so, yes, again, it just depends on what you're looking for, because a lot of people set up funds because they don't want, like to Emma's point, they don't want to be actively involved in doing all that stuff. But we've done a lot of recently, and I've done these where I represent both funds, and I've done it where I represent one fund and then another attorney represents the other. But yes, if you're the only fund, we can structure a joint venture. So the way I would structure this, see if I can explain this without a diagram, but the property would be owned by a joint venture LLC, right? So the property.
Go around.
Hold on a second, let me. Sorry, the little background there. So I would create a joint venture LLC that actually owns the property, and then that joint venture LLC, for example, would be owned 50-50, 50-50. I don't know why I've got this and keep muting it there. Make sure you keep muted. It's Heidi. Heidi keeps on muting yourself there, Heidi. So I would create a joint venture LLC that owns the property, and then your fund can own 50% of that joint venture LLC, and then the other fund can own the other 50%. So now you're both 50% owners of that joint venture, and then you both co-manage. That would take you outside of all those issues, because again, now you're actively involved in the deal. So I have structured it that way if you're just the only one. I don't know if that made sense enough, but we have done those.
Thank you.
Yeah, thank you. Tim, you want to ask a question about family offices? You're mute. We had this issue last time.
Hi, you're right. The double mute.
Yeah. No.
So I'm not too familiar with family offices, but are those basically just treated with the same rules as fund to fund? I mean, with a joint venture and all that, or?
No, I mean, there's so many ways. I mean, a family office, I have dealt with family offices actually when I was back syndicating. A lot of times family offices come in with debt, and they want all the benefits of that, first in, first out. They get paid first. They're family offices generally are less not that they're not interested, but they're less interested in the return. They're looking for preservation of capital. So that's their number one criteria. So they're not looking for huge returns. In fact, most of them probably don't want more than 7 or 8%, because they literally want to keep up with the rate of inflation. Now they might want 13 or 14% because they want to keep up with the rate of inflation. But they're much more concerned about preservation of capital. So they're going to be first money's in, first money's out. They get paid first. They're going to negotiate all those terms. But no, there's nothing special about that. They're just, it's almost like a fund. They're a fund of funds in the sense that they're coming in with a big chunk of dough usually. And so they will negotiate better terms for their family office. I can assure you of that. Right. And they may have they may request veto power, like, hey, we want to see. So they're a little bit more involved in that, but it's no different. There's no magical thing. They're not broker dealers, or there's nothing magical about a family office other than their investment philosophy, because they're more interested in preservation of capital.
So they're exempt from these SEC rules.
No, they're not. No, they're not exempt at all. So they're just think of a family office as a super high net worth individual. Right. So they're just coming in with their own money. Essentially, it's a founder that's, got a lot of times it's just somebody who got a huge exit, has $300 million. And so they create their own little office, and they hire an investment officer, and they've got their own little team, but it's just one person's money or a family's person's money.
I see.
So,
yeah.
But again, just like a fund of funds, because they're writing a big check and they want preservation, they usually want really preferential treatment, but they're not raising money from other people. It's their own money.
I got you.
If they're raising it from multiple people, then it's not really a family office. It's really a private equity firm that has multiple family offices, would be, I guess, the way I would describe it. And then private equity firms have the same issues as everybody else. They either have to, a lot of private equity firms do have broker dealer licenses, but if not, it's the same rules as everybody else. I just don't worry about them, because that's not my problem as to whether they're complying with their rules. But no, a family office would just be considered, think of them as an ultra wealthy individual investor.
I got you. Thank you.
Yeah. Thanks, Tim. Emma, why isn't raising capital considered significant? It is significant, but it's not substantially what they're trying to. They're trying to come up with exemptions to having to register as a broker dealer, and so if you have substantial duties, the argument is you're not really out there getting compensated to raise capital, so you're not really acting as a broker. But you know, and a lot of times this has to do with startups. So it's like, once you raise the money on the startup, what are you going to be doing? Because if you're not doing anything, then you're just raising money, which is just broker dealer activity. So that's the issue there. All right, I think I got everybody's questions. I don't know if I missed you for some reason, I apologize. If you want to, and by the way, I think somebody may have requested something about the Series 65. I'm gonna make a note of that because I don't think I ended up getting the question. But when I send out the replay instructions, I'm gonna send out. I did a checklist. Actually, no, that's got nothing to do with this. Never mind. I was gonna do something about a Series 65 checklist, but that's something else. If any other questions, if not, I will look forward to seeing you guys next week for the Russell Gray. One that should be a really good one. So again, thank you so much for spending your Wednesday evenings with me, and looking forward to the next one. Thanks, everyone. Appreciate you guys.